Good evening, everyone. A very warm welcome from Tekdi Technologies, Legal Logic, and Data Protection Education. Guys, we are having this webinar on practical insights on Digital Personal Data Protection Act. So, what we are looking for, guys, the key takeaways we are looking from this webinar are the prioritizing of data protection and the compliance readiness part of it, assessing impact on the business operations, and the leveraging this technology to strengthen the privacy. To discuss this, I have with me, we are three panels. So before we start, there's a disclaimer that this presentation is solely for information purpose and should not be taken as a legal advice. Mind you, all those who are watching us, that the provisions of Digital Personal Data Protection Act were rolled out in August 2023, and now the draft comments are already out by the government of India. None of the companies like Tekdi Technologies, Legal Logic, and Data Protection Education, it does not warrant any content or information contained in this presentation is accurate, correct, and complete. We assume no liability for the interpretation and or use of the content or information in this presentation. However, to make this presentation and webinar more interesting, more knowledgeable, we have the experts with us. So let me introduce with each one of us. So myself, Janardhan Khadilkar. I'm a seasoned military leader with over 22 years of experience, primarily in communication and IT domain. Presently, I'm working as a project manager with Tekdi Technologies Private Limited at Pune. Our legal expert is Mr. Karan Raja. He's a senior legal advisor at Legal Logic Consulting. He, as a data privacy lawyer, he has implemented of data privacy frameworks at an organization level and is expert in advising on compliances with data protection laws. Our third expert is Mr. James Singlet. He's director at Data Protection Education with extensive experience in the data protection for the education sector. James works from UK. He has adequate experience in ensuring the GDPR readiness way back in 2018. So, folks, what we can expect out of this webinar. So I take your mind back to our first series of the webinar, which we did on 31st of July, wherein myself, Karan, and one more colleague, Manoj, we had discussed about the future of data privacy and DPDP and your projects. Mind you, at that point in time, the draft guidelines which were promulgated on 3rd of January this year were not promulgated, which you can see on the right of your screen. On the left of your screen, you can see the original screenshot of the Digital Personal Data Protection Act, which was given out in 2023. So with this as a slight background, what are things we are likely to cover in this webinar? So we'll be primarily focusing on draft DPDPA rules. What's next for the organization? I'm very sure that organizations, businesses are keen to learn as to what is next action, what are the key action points for them. We have had a complete rollout of GDPR, the famous privacy law for the European Union. So we have James here who's expert in that. So we will be definitely looking forward for learnings from James. Lastly, we will be talking about the preparedness for the key compliances and the obligations. So audience can definitely go back with a fair amount of understanding. At the end of the webinar, we'll be also be hosting a Q&A session, which will clarify further doubts. So guys, let's begin our chat. So allow me. Okay, so welcome Karan, welcome James. Welcome to this chat, this panel discussion. And uh, what I'll start with is the recently the draft rules were published on 3rd of January, to be precise, and the government has requested all the Indian citizens to give their comments, to offer their comments by 18th of February 2025. The draft rules have provided adequate clarity on the operationalization of the compliance requirements. So let's understand from our legal expert with the publication of the draft rules. So Karan, with this, I'll open the session with a question to you that on which compliance aspect does these draft rules provide clarity? If you can educate our audience.
Yeah. Thank you, Janardhan. As rightly said, the draft rules were released on 3rd January for public consultation, and comments on the draft rules are invited till 18 February. So the draft rules provides us clarity on the structure format of a privacy notice. It identifies the baseline requirements for security safeguards that needs to be implemented by organization. It further specifies notification timelines and dual reporting obligations that would be applicable during a data breach scenario. It highlights data retention timelines for specific class of data fiduciary. Also, obligations associated with obtaining children's consent. There are some additional obligations for significant data fiduciaries. The functioning of the board is also set out. It provides guidelines on the mechanisms of exercising individual rights. It highlights the appeal mechanisms. It also stresses upon the registration requirements and the obligations that would be applicable on a consent manager. So, on a whole, a lot of clarity is provided on a lot of compliances through the draft rules.
Okay, all right. So I think with this sort of a clarity emerging from the draft rules, Karan, as you brought it out on various aspects, what should a small organization or a small business should be actually be doing to prepare for this compliance?
Right. So small organizations often find it challenging to address questions that are in the nature of what needs to be done to meet compliance requirements, when to begin compliance requirements, who in the organization will take responsibility of compliance, whether it's IT, legal, how much do we need to rely on technology? Are there any requirements to create org level policies, procedures, or how do we manage incidents that are associated with data breach, or how do we share data with vendors? So, to address these questions, it is important to first understand the impact of DPDPA on the operations. How do you do that? How do you understand what is the impact of the law on your operations? So, to begin with, a data privacy assessment will help organization to understand the impact. So, the assessment basically maps the data handling practices of an organization with the requirements of the law. So, with this mapping, the stakeholders of the organizations are provided granular visibility on important aspects such as how the data is flowing in an organization, the data sharing mechanisms, the data retention practices, how is the organization prepared to handle a data breach, is the organization ready to demonstrate the compliances? Is there a dependency of technology? And ultimately, through this assessment, the organization is able to identify gaps in their current practices or operations, and accordingly, they can take steps to mitigate such gaps. This, I think, would be a good starting point for any organization, be it of the size of a small, medium, or enterprise level organization, to get a sense or to get a true visibility on the efforts that it would require to invest in public in the people, processes, and technologies. So that is a good starting point to first understand the impact of the law on your operations through an assessment.
Okay, great. Thanks, Karan. That's a, I mean, great answer for any organization who has got very little clarity on that. So with this question, I would like to go to James, who is having an extensive experience in implementing the GDPR in European Union way back in 2018, which is being one of the most important compliances. So, James, like my first question to you would be, how can Indian businesses or organization, what can they do to avoid the mistakes which were done or the errors which were there in the GDPR or the European Union companies to meet these compliances? How we can effectively deal with this?
Yeah, thanks, Janab, and thanks, Karen, for those responses so far. I think, firstly, I would say that there was 2 years to prepare for GDPR, and I think one of the biggest mistakes that organizations made was probably complacency. The fact that they may not have used that time wisely to actually do those audits, those gap analyses, those benchmarking and privacy assessments to make sure they really understood where they were against the compliance of what was going to be required and coming. One of the things is that it was seen as an additional level of bureaucracy. Many of the actual things within GDPR actually did exist before, but the accountability principles certainly changed. And that meant you had to document what you were doing and you had to make sure you were doing these things. And much as some other changes as well, it was these that were seen really as adding additional levels of bureaucracy. And I don't think really people appreciated the fact that actually going through and reviewing where they were would actually allow them to seek the benefits of actually being compliant with the law through process efficiencies as well as just good operational compliance. And it leads to a question actually of, what does good compliance look like? And I think that's where really the benchmarking is an important thing. And it's doing a proper analysis of where you are. And this is, to be fair to say as well, that I think one of the mistakes made within GDPR itself and within the law potentially, certainly how it was perceived, is it was very much this one size fits all. It doesn't matter whether I am Google or Facebook or whether I'm the local electrician who's got processing personal data. Everybody has to do everything. So I think that sense of perspective and proportionality on the law as well was a concern for a lot of people that led to people thinking, I don't really need to do anything. It doesn't apply to me. And it will apply to you on some level or other if you're processing data. I'd say that most of the operational work with the implementation was done around policies and training and documentation, but there's an underestimation of what that actually involves. Certainly we can all download a set of policies from the internet, but we need to make sure they are quality, that they are actually approved by your legal consultants to make sure those are quality documents. And when you're managing all this system, rely on the technology that might be in place to actually help you with managing breaches, with training and things like this. Cultural shift as well, I think, is one thing I would just like to mention quickly, that actually I think getting people to be aware of what the requirements are at the staff level rather than just in the leadership level. And this particularly applies when we're changing the culture of what's required for reporting data breaches, because we need to have a culture of openness that people are confident that they can say something has happened, they can report it and make sure the requisite steps are then taken to follow. I'd just like to, I could go on for a long time. I just finish off by just sort of highlighting the effectiveness of some audits, and I'll two examples I can think of. I won't go into the details, but one of them was a very positive audit. It was an organization which had looked at the regulations. It had said, okay, we need to put these things in place. And the audit was a very useful thing to do. They were pretty compliant on those things. And it was a great validation for them about being able to take that to the board and say, yes, all this work and investment that we've done is actually making sure that we have a really good start when it actually was implemented. The other side of it was an organization who just thought, well, we're pretty good at everything we do. And we went there and found a lot of problems. And yeah, what it did, the product it produced actually was quite good. But actually, this whole thing around data protection law, actually, it was missing so many things. They hadn't done anything, they were complacent, and there was a lot of gaps. The danger was that they went away from that thinking, I'm sorry, we still think we're pretty good and we're not doing anything. And there'll be consequences down the line. I always say about data breaches, it's not a question of if you have a data breach, it's when you have a data breach, and you need to be ready to go. So use the appropriate tools, use the appropriate legal expertise available to you to make sure that you're going to be prepared.
Yeah, thanks, James, for this very comprehensive answer. And you have actually, rolled out like a screenplay, like how compliance needs to be actually executed, and a very relevant lessons you have told us. So with this, I'll take the discussion ahead that through an assessment, the organization will be able to gauge their preparedness. This is what has just come out of our discussion to meet the compliance requirements. So let's understand what would be the key compliances that would have an impact on the operations in the light of DPDPA. And I'll request Karan to just throw light on this. That which are those
Yeah.
key compliances that would have an impact?
Thank you, Jana. Thank you, Janardhan. So there are many compliances, but the key compliances, as you rightly pointed out, the key compliances would be compliances around consent, data breach, and vendor management. From a data privacy perspective, I think are the three most key compliances that every organization, depending upon, irrespective of the size and the level of personal data they access, needs to comply with.
Okay, so with respect to the consent management, we have just spoken that maybe we can call it those three cornerstones of consent management, data breach, and vendor management.
Correct.
So I would like to ask Karan on the consent management part because probably this is needs further deliberation. So how can organization meet these consent management requirements?
Sure. So consent, if you visualize granularly, it forms the bedrock of the DPDPA regime. So apart from few instances, organizations will require to rely on consent for processing data. Now, I'll help you with a use case scenario wherein we can discuss how this consent compliance can be gone through. Say, for example, a company offers a personal finance management app that helps its users to track expenses, investments, and provide analysis about its spends. Now, to provide the summary about the expenses and analysis, the company collects personal data of the users, contact details for registration, data about expenses, investments, which also includes personal data such as bank details, location data, etc. That's the inflow of the data. To use such data, the company will be required to obtain an informed and specific consent from the user. Now, how will the user give an informed and specific consent? So that the user will need to know about the company's practices in relation to handling of the data to provide an informed consent. So while obtaining the consent, the company is required to provide a privacy notice that provides an entire visibility to the individual or the user about the usage of personal data, the disclosure practices, and the ways to register any grievance, exercise their rights, so on and so forth. Now, further to demonstrate that the company has obtained consent, it will require to maintain consent logs, have the capability to retrieve consent. It should also have the facilities to withdraw consent. So here it is important to note that apart from the legal documentation that goes while collecting of the consent, there is also a heavy dependency on technology as well to meet the consent requirements. Accordingly, a framework that includes legal documentation and that is backed by technology needs to be devised to meet the consent requirements.
Okay, so very well explained. So let's take the discussion ahead with respect to the data breach management. Of late, we have seen a lot of cases wherein the data breach is happening and the data of important functions like financial data, insurance data is getting stolen. There are reports of ransomware attack or any such like incidences. So my question to James would be, what have in the as far as the European Union is concerned, what have the businesses done to meet the data breach efficiently and effectively, and what steps they have taken to meet the notification requirements?
Yeah, this was a big problem for a lot of people. So the notification requirements are that if there is a data breach, and these are a little bit different than for GDPR than DPDPA. But if there's if there's a risk to the rights and freedoms of a data subject, which is effectively the data principle sort of equivalency, then you have to report this to your statutory authority. So in the United Kingdom, that is the Information Commissioner's Office. And you've got to do that within 72 hours. And the understanding caused a lot of confusion initially about what actually meets a threshold of reporting. So the Information Commissioner's Office actually gets a lot of things still to this day reported to them that actually doesn't meet the threshold. And their online reporting system have actually made it a little bit more difficult than it was initially to actually ask just to pre-qualify some of those things to see actually, are you really sure? The other thing then is it's a slightly different threshold for letting the actual individual know about their data breach, for data breach which has occurred. So this would actually not just be whether there's a risk to the individual, but whether there's a high risk to the individual. So we're straight into the way of, as with many data protection and data privacy laws, that was these sort of balancing tests of, well, is this a high risk? Or is it not so high? Should we tell them? Should we not tell them? And I think there's and I'm sure kind of explain, there's a little bit more definitiveness, I think, sometimes about what's happening within DPDPA. So I think that was one thing where there's just been confusion about it. The thing I would always say is you need a data breach procedure. You need to understand what you're going to do. And you may have these anyway if you're doing something around ISO 27001, some other information security standards. You may have those, but you need to be able to look at actually what's the impact on the organization from this data breach and what are the impacts on the rights of the individuals for this data breach. Because there may be other consequences. So in the UK, for instance, you may get a fine, or in Europe under GDPR, one of the big selling points to get people to comply was the massive fines that everybody was going to get. Not many people have had those massive fines. And I look at it and I think, well, actually, the risk of a data breach to you is operational disruption if you've had a ransomware attack. Also, the public relations disaster which can ensue, because pre-GDPR, the BBC, our broadcasting corporation, never would you see anything unless it was really, really significant. You'd never see anything about a data breach which had occurred. Now you can go onto websites and mainstream news outlets will report on data breaches which have happened. So I think this has changed a little bit. So I think about understanding what do we need to do to report to people? When do we need to do it? Make sure you've got those procedures in place. And again, I came back to a point I made earlier on. It's the cultural shift. A lot of the time when people have done something, if I look at the information security dashboard from the Information Commissioner's Office, and you can go online and look at it yourself, the thing at the top, which when I last checked was 17% of reported issues were email related, usually about using CC rather than BCC in emails. Not all of those are consequential, but I can give you an example where it might be, where one of the recent fines was for an organization that sent out using CC rather than BCC emails to everybody on the mailing list who was HIV positive. So it's not always the content of email, it's the context around the data. But with that, it's about the culture of getting somebody who sent that email to admit it straight away, to be able to do something about it. Can we recall that message? Is there other things we could have done? I mean, my advice on that one is never use BCC for sending group email messages out anyway. Use a mailing list. There's better ways of sending those communications, but it's that culture of understanding there's a problem here and not getting people to hide from it and actually seeking the help within the organization to rectify it before these things get out of control. We all know from within any data breach, the faster we can contain, the less damage is likely to ensue. So it's all about thinking about your procedures, thinking about what is your risk and contingency planning for those risks. The GDPR does not tell you. All it talks about is technical and organizational measures which must be in place, because we know that the technology changes over time. So we really need to understand and have effective business continuity planning, cyber incident response planning, etc., whatever you want to call it, whether it's just in your general risk register that you might be running in your organization. We need to think about what will happen if this happens, because I say it's not just a question of when, it will happen at some point in time, and the better prepared we are about notifications and understanding what to do internally, the better prepared we are to actually deal with them when they happen.
Yeah, all right. I mean, very insightful, James. I mean, right from Information Commissioner Office input to 72 hours of notification till a simple thing like doing BCC and CC. Like we all use email, but this point is generally missed out. So very insightful answer, I must say.
I would say just on that to jump in. Sorry, I think a lot of people probably don't need to report all those issues. I think there's probably a lot of action which is not taken by the Information Commissioner and related to those. But I say it might be that somebody just sent something out to two people and all that's been revealed is an email address. The example I gave actually has far more consequences to it because of the nature of the group that it was being sent to. So it's always about what are those, looking at the risks, not only to the business through the data breach, but thinking about what are the consequences to the individuals whose data has been breached. Sorry, Janelle.
Yeah. So very true. So thanks for those insights, James. I mean, a lot of examples you quoted. So Karan, I'll come back to you that from DPDPA compliance perspective. So what are the additional needs, to be done, considering what James has just spoken? He has spoken about a lot of things. So how we can connect those dots in this context?
Yeah, one thing is very important to note here is that the notification requirements, the reporting timelines are there. But when it comes to DPDPA, we do not have the leeway or the convenience that GDPR provides with respect to harm-based reporting or with respect to the risk that is associated to an individual when it comes to reporting to to notifying to an individual about a breach. Here, irrespective of the harm, irrespective of the risk, we have to notify that individual. I'll take an example here to help the audience understand the complexities of a breach. So let's take an example where there is a misconfiguration of an internal server of an company. Now, this internal server basically has stores employees' email addresses. That's it. And this email addresses are exposed on a public cloud server. So here we can gauge that the amount of risk to the data that is exposed is very minimal, or the sensitivity or the harm to the individuals whose email addresses are exposed in the public domain is very minimal. But considering the DPDPA, the organizations will need to notify the individuals immediately upon becoming aware of such a breach. They will have to notify the employees or the users about the event that is occurred, that is a breach. with the notification, they'll also need to help them understand what is the data set that has been breached, what is the action that the organization is taken to mitigate these breach, what is that the user can do to avoid or during these breach situations, and ultimately after reporting to the individual, the organization has to report the same incident to the board, the Data Protection Board of India, and to certain as well. There are dual reporting obligations. So just see the amount of complexity that is there in case of reporting a simple incident which under the GDPR would not have been construed or amounted to report to an individual. So here the organization needs to, so what does an organization need to do where it is required to report such incidents to the individuals or users? This was a small number, but consider there is a large organization with a lot of number of users. How does it then manages to report such or notify such individuals about the breach? So here it is important to at least have a robust framework which helps you identify a proper incident reporting mechanisms. You should at least able to monitor the logs that are there, because under the law there is also a requirement under the draft rules. They are saying that the organizations need to have detection systems that would manage, that would identify unauthorized access. Organizations should be prepared to handling the external and internal communication strategies. They should be prepared to liaison with the authorities in a time-bound manner and also address the individual's queries. They should be prepared with their insurance claims. Also, there is a requirement under the draft rules which states that to avoid such breaches, earlier, the DPDPA just said that you need to implement organization security safeguards, but the draft rules have gone further to help us understand that these security safeguards could include baseline requirements such as encryption mechanisms, such as obfuscation of data, masking, reliance on virtual tokens when it comes to implementing such requirements. There are also requirements in relation to implementing access controls, having adequate backup to ensure continuity. Log monitoring is another aspect that needs to be handled. There are certain timelines identified for retention of logs. This is 1 year period is identified timelines to retain logs to, so that you could be able to demonstrate what you've done or to identify or investigate the breach. So for such instances where the risk is minimal, the organization will need to go through this entire process or procedure when it comes to breach reporting. So in under the DPDPA, it becomes slightly tricky, and thus every organization needs to rely on certain robust framework which could include policies. And again, here also, you would see that there is a dependency on technology. Without technology and without your adequate response mechanism or the policies, you would not be able to you would not be able to handle such incidents, which ultimately cause a lot of reputation damage, loss of goodwill, and operational hazards as well.
Yeah, thanks, Karan, for this comprehensive answer. I think businesses or business operation need to heavily look at taking the advantage or taking the help of technological framework in what you have just said, because they need will need a lot of clarity and a lot of infrastructure building in order to implement this. Yeah, so thanks for this comprehensive answer. So let's take the discussion ahead with respect to some vendor management issue. So we have spoken that vendor, let it be any industry, any service, maybe healthcare, pharma, whichever sector is serving the clients or the customers. So they have certain obligations, they have certain duties to perform. So Karan, are there any compliance related obligations which are there in the framework of this law and which are directly applicable to the vendors? And if yes, how the vendors should be dealing in totality?
Yeah. So, Janardhan, under the DPDPA, there are no direct, unfortunately, there are no direct obligations or compliance requirements that are applicable on the vendors or third-party service providers or the data processors, as we may call. Here, the DPDPA holds the organizations, that is, the data fiduciaries, accountable for the vendors act of the vendors or the vendors data handling practices. The organization will be responsible or accountable for how your vendor or the service provider handles your data. So let's take a quick example to understand what it would go for an organization and what it needs to prepare when it does an onboarding. So every organization, small or large, usually outsources its payroll processing to any vendor or any service provider. Here in this scenario, uh, just let's say if the vendor accidentally exposes sensitive data of employees such as salary details, bank account details to unauthorized recipients. So here just imagine the repercussions that would arise out of such unauthorized disclosures. It would be severe, right? Now, is the vendor directly liable? Whose responsibility it is? But here, under the DPDPA, the organization itself will be held responsible for such an act of the vendor. It would be responsible to answer to the data principals in relation to their unauthorized use of this data. So here it becomes very important for organizations to understand the circumstances and consequences. So it becomes important for them that whenever they are appointing a vendor, they need to do a thorough due diligence. They need to thoroughly understand how is the vendor preparedness about its privacy, whether they are able to safeguard the data. They should be able to demonstrate the compliances or the minimum security safeguards that they have implemented. After doing a thorough due diligence, how does the organization mitigates such risks, or how does it offloads the liability that would have been caused by the act of the vendor? And this could be done through robust contracts. The draft rules also mentions that the contracts between the organizations and the vendors should have a say on the security safeguards that have been enabled. So therefore, these contracts would help organizations to minimize the risk, would help in risk mitigation. And finally, there has to be regular monitoring and audits when it comes to safeguarding such incidents from vendors. So we should be regularly monitoring and auditing our vendors when it comes to helping them demonstrate their compliance requirements, or we should at least understand where do they stand in relation to the compliance and security safeguards that they have implemented.
Yeah, thanks, Karan, for that answer. So, the similar question I would like to ask James, that in the context of GDPR, James, as brought out by Karan, in the context of DPDPA, the vendor accountability has, I think, been a major compliance challenge, wherein there were issues in how to get this compliance done, how to ensure this, how to monitor this. So, what best practices can Indian companies adopt in order to manage these third-party risks? Any lessons learned out of your extensive experience?
Yeah, I'm just going to point out a couple of things which might be blindingly obvious, but there's a slight difference in terminology under GDPR. So we talk about data controllers, which is effectively the data fiduciary, sort of, which is the organization that decides what information is being collected. So they will work with the vendors, and in GDPR speak, we call them data processors. And the definition of data processing responsibility is quite clearly defined under GDPR. But ultimately, it makes it very clear that, a data control, the person who's deciding what happens with the data, should only work with that processor or vendor where there are sufficient guarantees that they are going to implement proper organizational technical measures. Again, it's putting it on the person who's actually deciding what happens with that data. You can't say, actually, we gave this information to this other organization, we've had a breach. It's not our fault. It's your fault because you chose them. And it comes back to a lot of the things which you need to define have to be within the contract. One of the issues that we have is that sometimes we aren't always going to an organization and saying, this is my contract, this is how I want to work with you. I want you to do this for me. So in the case of Microsoft or Google, we are just signing up to their services and we get what we're given. And sometimes it's not always quite clear that it's still your data. So who is actually the data controller and who is the vendor in these situations? Because they are deciding what to do with things themselves. So we always have to make sure that there's a decent contract in place. And I think that's one of the issues, and really understanding about what organizations do. Do your homework on what data and what you really need those organizations to do. So what information are you giving them? What are they holding on your behalf? What happens to it at the end of the contract? Are you confident that actually your retention schedules are being applied to the people you've passed on your data to? And it comes back to that audit point that Karen was talking about here. You need to make sure, because you are contracting with these organizations, your contract should be meeting all the clauses required under whatever data protection regime you're working on. You need to make sure that the contract covers all those elements so that you are in control and the responsibilities are set. And often it might be that the insurance levels are set accordingly for indemnity insurance. One of the other things about when you're doing your due diligence on suppliers is don't assume you've done it once and it is done. There is a clause within GDPR that allows you to audit processes and sub-processes even. However, that often doesn't get taken up, but you can do your due diligence. And the reason why I suggest it is that you may be using a vendor, let's just call them Microsoft, and all of a sudden they introduce a tool which is doing something different with your data, Copilot. And they never did that when you started and you signed up for Office 365 with Microsoft 365. You didn't have that AI capability built in, but it's introduced for you. All of a sudden there's something happening else is happening with the data that you are using them for. So are they then going to use that data for training purposes? There are other risks to the data. So always make sure your due diligence is kept up to date and you're asking the right questions, and don't be scared of asking the hard questions and chase, because a lot of organizations will not want to tell you.
Yeah, so that was a very comprehensive answer. Came straight out of your learning, James. So, Karan, my next question to you would be like, as a common citizen, like I generally I'm deeply connected with the businesses like daily selling or buying daily goods, healthcare industry, uh, the things which are I'm in direct contact with. So, as a common citizen, so what are my rights and responsibilities with respect to this DPDPA? What a common person needs to understand out of this, and what he needs to actually know.
Yeah. Thank you, Janardhan. Yeah, so under the DPDPA does a balancing act wherein it recognizes that organizations will need personal data to process as part of their operations, as part of the services and the goods that they provide. And also, they empower these individuals on the other side with certain data privacy rights. Now, what are these rights? So, here, as a common individual, an individual can ask an organization about the right to access, can exercise the right to access, which is it can ask questions directly to an organization. Help me understand what is the data that you have about me. Help me understand where did you acquire this data. Help me understand, did I provide you consent, or do you have an authorized consent while you're reaching out to me? So I, as an individual, if I'm not sure about how my data is reached or being used by an organization, I do have a right to directly check with the organization about how did it get my data. That's the right to access. I can also understand from the organizations whether this data is being shared with any other third party organizations through him. So I can have the entire visibility or the access of my data, personal data, that is being handled by the organizations, in relation to my data, in relation to the access. The other rights are in relation to modification and deletion. I can request the organizations to modify the data that they have. They can make the necessary revisions, and also I can ask the organizations to delete the data and stop the processing if I want them to refrain from that. Interestingly, these rights are usually common across various data privacy laws across the globe. Under the DPDPA, there is an additional right that is being highlighted or provided to an individual, is the right to nominate. So here, what this right suggests, that in case of death or incapacity, I, as an individual, can nominate any other person who can exercise the rights on my behalf. So this is an additional right which is being provided to common citizens in relation to exercising of their rights. So this is the way how the law empowers the individuals with the rights. With rights, there are certain responsibilities. Responsibilities, when it comes there are certain duties when which are there. So these duties are in relation that whenever you are raising a complaint or sharing some data, you need to ensure that the data that you are providing is accurate, it's true, you are not providing any misinformation, or if you are revealing any facts. And also, you are not allowed to make any false or frivolous content. So with rights, there are certain duties that every individual needs to be mindful of.
Oh, that was a great answer, Karan. This reminds me of this famous sentence in the movie: "With great power comes the responsibilities as well." So you have correctly summed up as to how we can balance it out. Friends, we are coming to end. Uh,
Yeah, James, go ahead.
yeah, yeah.
I think one thing which is part of the question is obviously under GDPR, one of the things we've talked about, having documentation and things, is one of the first things you need to do to prepare. So obviously one of the rights under GDPR is the right of transparency, which generally manifests itself through privacy notices. So this is a question really: is DPDPA, is that classed as a right, or is that just classed as an obligation on the data fiduciary to make sure that they issue the privacy notices?
It's an obligation on data fiduciaries, along with the consent to share a privacy notice, that would help the individuals understand what the organization is doing. So it's an obligation rather than a right of a transparency.
Yeah. But in both regimes, I think it's a really important mechanism that people have to have in place to make sure you're letting people know what you're doing with their data.
Correct. And with the rules, it has been more clarity about the notice requirements. So yes.
Thank you.
Yeah, so before we are about 5 minutes short of our designated time. So with this, I'll take on the last question from my side for today's evening before we go on to the Q&A part. James, so my question to you would be, you have seen the complete transformation of getting into a compliance, the rolling out of the particular compliance, and now you are seeing it, say, maybe 5 to 6 years down the line. How technology has helped you in achieving this, And what would you be advising the Indian businesses, Indian people to use or to capitalize on technology? How can this be used as a force multiplier in achieving this compliance?
I think there's various different areas. So I always think starting off at some of those really basic things that we want to have in place. We need, logs and we need training. Now, those can be done offline. There's plenty of people who say, well, I'm just keeping my logs on a spreadsheet on my desktop computer. I'm just going to do training by having a staff meeting. I think whenever you're doing anything which is compliance related, where somebody down the line may come and want to audit what you have done, actually keeping really accurate records, technology plays a strong part in this. So using proper logging systems that will do this. I think with training, compliance training, I'm a big fan of actually e-learning. Just because actually we have a dedicated record that one user has had for training on a particular data, we know when that training needs to be refreshed. I think various tools that can be done for automating reporting of data breaches are quite useful. So in your breach log, you may have a mechanism that actually allows you to report to the data protection board, for instance, down the line, that actually automates these things. So it becomes easy rather than you removing a lot of the manual overhead and procedural elements. Within the wider context of one of the big problems that data protection law generally introduces everywhere is this right of access. And if somebody starts saying, what is my data? I want a copy of my data, which is allowed under GDPR. And I think because we've got all these different systems which exist, I think sometimes it's very difficult for people to understand where the data is and also to gather all that data together. So there are some really good e-discovery tools out there that will help identify where data is and collate all that together. So these tools are really useful. When you give out some of that data, making sure information is redacted properly and using tools to redact. So one bit of technology, which doesn't have to be that expensive, is using electronic tools for redaction rather than using redaction pens and doing it offline and photocopying and re-redacting it. Because I can guarantee, unless you're going to spend a long time doing it, you will be able to make out what's written underneath. So I would always say use a proper redaction tool as well. There's lots of really good technology out there as well for your records and your documentation around GDPR and seeking answers to questions as well. So just professional resource banks and using the technology to help really identify where things are going with the data that you hold. So keeping a logs and track of all your vendors and your vendor management. All these kind of documentation elements, I think, are really important elements which technology can do. And, then there's probably other ones which I haven't even thought of at that point in time as well.
Yeah, so great answers, James, and we have actually learned very good lessons, and it has come out very clear that the technology is going to be the driver for a speedy and an accurate implementation of this. So with this, guys, we have come to the end of this chat. Of course, we'll be taking on some questions, if any. But before we go on to that segment, let me just conclude what we have just been discussing in last about an hour or so. And folks, we discussed that cornerstones for this executing this Digital Personal Data Protection Act are based on three important things. That is consent, data breach management, and vendor due diligence. Whosoever wants to, or like everyone will have to implement this act law in some point in time. However, while implementing this, these three things have to be kept in mind, as brought out with ample examples by James as well as Karan. Consent is important, consent management is important, how the data breach is being managed, how it is being reported, whether the timelines are being followed, whether the procedure is being followed is very important. Whosoever is the vendor providing specific services, how he is carrying out due diligence while protecting, accessing, as well as using the client data is also important. So this complete compliance is based on these three cornerstones. Training and awareness is very important to understand, to get to the execution of this particular act. So by the mere fact that we are having this webinar to generate awareness and let the people know that such and such compliance is round the corner, we need to be prepared for it. This can be achieved only through training and more awareness. As and when it gets rolled out, adequate training in form of getting these key compliance areas, specifically focusing on the areas which that vendor needs to implement or execute. The training of staff is also very important. And finally, we discussed how technology can be leveraged. It can assist you in getting. James and Karan both spoke about a lot of compliance management activities which can be effectively managed by a technology which will be a key driver in the times to come. I think we have had a very good discussion on this. So, taking forward this point of use of technology, guys, at Tekdi Technologies Private Limited have worked on an AI-powered chatbot. We have named it as Secura, and now we'll be launching this AI-powered chatbot. It is having we have fed this bot with the important documents with respect to DPDPA. That is, there are two important documents with respect to DPDPA. So here is the QR code for this Secura bot, and also link has also been provided. So this Secura bot can actually give you ready-made answers for the key questions, which you can ask to the bot and you can get it done. So audiences who are there, they can scan this QR code. They can this link will also be subsequently shared, and you can use this bot. Please have this bot tested, check, give us the feedback, and more information can be shared out of this. So I'll just allow a few seconds for the audience to scan and copy this link, maybe scan the QR code. Okay, with this, we have come to the end of the session. Are there any questions? Please feel free to ask.
If an Indian company faces data breach from international organization, say from an European-based organization, the legal aspect of it, will it adhere to GDPR or DPDPA in such a case?
Yeah, so we have a question.
Yeah.
So, Karan, would you like to answer this?
Yeah. So the compliance obligations under the GDPR and the DPDPA would trigger once we identify what role we are playing here. So when, suppose if we are playing a data processor and we are handling an EU individual's personal data, which is being shared by our client, then the compliance obligation under the GDPR would be to immediately inform the data controller, that is our client, about the incident that it has happened, that if we come to know about the incident there, and but in case of DPDPA, if we are handling individuals' personal data. So if we are a data fiduciary in that case, where we are handling individuals' personal data, where we are determining the means and purposes of processing personal data, there is a data breach kind of an incident. Then there is a dual obligation, that is in relation to reporting to the individuals as well as reporting to the board, in case of a data fiduciary. But when we are acting as a data processor, Here, our obligation is similar to that in the GDPR, that we simply need to inform the data fiduciary or the data controller. So depending upon the role that we are playing in the capacity of a fiduciary or a processor, the obligations in relation to notification would get triggered and under the respective laws. I hope that is.
Yeah.
Yeah,
So thanks.
just one. I agree with that answer entirely. It depends entirely what the relationship is. You could extend that use case and say that company in Europe, for instance, is also processing the data of Europeans. So therefore, they'd end up rolling it back up to the data controller, who would report it internally under GDPR to the European statutory authorities as well. But if it's just the data of Indian citizens, then there's technically no actual responsibility for the data processor to report it to their statutory authority.
Yeah. Okay. So the next question from Shweta is appointing a DPO, data protection officer, is mandatory for all or only for the significant data fiduciaries? So Karan?
Yeah. So appointment of DPO is under the DPDPA is mandatory only for significant data fiduciaries. However, for other data fiduciaries, for normal data fiduciaries, the law mandates appointing a point of contact that would be responsible to address or would act as a liaising officer that would address the queries in relation to data privacy aspects from the individuals, as well as liaison with the board. So it also mandates organizations to provide details of the point of contact prominently on your websites. Also, it provides mandates, or the draft rules say that you need to provide these details whenever an individual is exercising any right. So during that entire exercising of the right, the details of the point of contact needs to be provided. Also, the timelines within which the grievance or the right would be addressed is also to be noted. So when you go to see that from a compliance perspective, from a mandatory law perspective, yes, DPO appointment is required only for significant data fiduciaries, but organizations will need to require appoint some individual or some team that is ultimately responsible for managing compliance within the organization. So the official designation may not be there as a DPO for normal data fiduciaries, but there has to be some responsible person or a team responsible for handling or managing the privacy pieces. Yeah.
Yeah, so great. I think Karan, you have adequately answered that question. So any further questions? I hope there are none. Okay. All right. Now I'll take your attention again back, because we discussed that technology is the key driver, and here we'll be now presenting how this bot is actually functioning. So I'll request my colleague to share the screen, which I'll be unsharing. Yeah. So we will just quickly demonstrate how this bot is working with simple questions. It is like a normal AI-powered chatbot. We have fed this. So this is the screen where the subscriber will be landing. It's a Telegram-based chatbot. So any simple question like what is DPDPA? So let's see what this bot answers. Yeah, so from the feeder document, what it was given to the chatbot, it has produced the answers by scanning through both these documents and certain other open source documents. So the subscribers or the people who are logging in they can ask a relevant question to this chatbot. So let's take another question that what is a data principle? So for this question, again, the chatbot has provided the answer. So my strong recommendation to all our viewers would be, please scan this QR code, and through your Telegram application, you can log into the chatbot. Please try it out, give your feedback to us. And as you are all are aware, as the model of the chatbot is based on more and more learning. So if you keep asking the question, you keep feeding the information, the bot will give you certain responses based on the documents fed. So try it out, guys, and get the power of this technology on which this complete thing is based. So with this, we have come to end of today's session. Please do not forget to share your feedback, share your opinion about this. Also share with us that any other particular topic or any other particular thing on which you want another webinar to be held. Please let us know through our social media handles or any other platforms. Please let us know that. So, and we will take that up. So here from Tekdi Technologies, Legal Logic, and Data Protection Education, I am signing off. Thank you so much for your wholehearted participation. Good question answer session we have. Again, my strong recommendation to try out this chatbot and let us know the feedback. Thank you so much and have a good evening. Thank you.